Hi, my name is Lacey, and I'm the chair of the higher education practice at Thompson Coburn LLP, which is a national law firm with offices located around the country. By higher education practice, I mean we have a group of attorneys at our law firm who spend all or most of their time working with institutions of higher education. And as some of you may know, if you're regular listeners, we produce a number of webinars and white papers and other resources specifically for our higher education community. We were talking recently and we felt like sometimes there are topics that we would like to cover and we'd like to be able to reach out primarily and preferably through video, but we don't have an hour or 90 minutes of content. We may just have 10 or 15 minutes. And so we've decided to develop this new idea. We call it the HigherEdReg Rundown. Try saying that 5 times quickly. And it's going to be a platform that we use when we want to reach out, again, through video with a 10 or 15 minute update. So this is our inaugural HigherEdReg Rundown. And today we're going to be talking about specifically the U.S. Department of Education's new financial value transparency and gainful employment rule and some recent guidance that they put out, which if you're following this rule or you're tasked with complying with this rule is going to be important and something you're going to want to start to track. The Financial Value Transparency and Gainful Employment Rule, as some of you hopefully already know if you're watching this video, was published last year, October 10th, 2023 in the Federal Register. The rule is currently set to take effect on July 1st, 2024. And again, the reason we're reaching out is because there's been significant guidance that has recently been issued by the department, and there is more significant guidance that we expect is on the way. If you are new to this rule and it's not something you've heard of before, this is probably not the video for you because this is going to be more along the lines of advanced topics, but we do have some resources for you. There is a desk guide that we put out late last year that provides a really nice and detailed summary of the rule and also a step-by-step process by which you can try to model rates for your institution. We also did a couple of webinars in November of last year where we covered a lot of the same material that was in that desk guide in video format like this, so you can follow along if you'd like. And if you want to access those resources, they are all available on our Higher Education Resources page, which is right here on your screen. All you have to do is scan this QR code and it'll take you right there. And again, you can get electronic copies of the desk guide, and the webinars are free. They're on YouTube and you can watch them at your discretion. If you are already wrestling with this rule and you've already been through those resources or other resources, then again, this is the update for you. The first thing we just want to highlight is that the department is really on a tear right now. They've been putting out a lot of guidance, not just about this rule, but about other rules. It's spring, and with spring comes U.S. Department of Education guidance. On March 29th, I think that was 3 weeks ago, the department released a Dear Colleague, during which it provided sort of an overview of the rule and started talking about some extensions with regard to reporting and other issues. On the same day, it released an electronic announcement. About a week later, on Friday, April 5th, the department launched its new Financial Value Transparency and Gainful Employment Topics page, where it's going to house all of this guidance. And it also released at the same time a new FAQ with some very specific responses to questions that the department has been receiving. And then finally, just this past Friday, so I'm recording this on Monday, April 15th, Tax Day, on Friday, April 12th, the U.S. Department of Education released some additional guidance regarding how institutions are going to be reporting all of the data that's required under this rule through NSLDS. So if there's nothing else you take away from this video, just please be aware that the department is starting to put out all of this guidance. It's got a website now, and if you are again tasked with complying with this new rule, then you want to be tracking this guidance and looking through these materials. But if you are here, the good news is we're going to talk about and highlight some of the most important concepts, at least we think, that you'll want to know about right out of the gates. First of all, the department has extended the reporting deadline. So under the rule as it was originally written and released in the Federal Register, the institutions were responsible for reporting a great deal of data by July 31st of this year, which was only 30 days after the effective date of the rule. The department has formally pushed back that initial reporting deadline to October 1st, 2024. So just to be clear, this means that institutions may submit the information that was previously due on July 31st, 2024. Now they can report it on October 1st of 2024. So institutions have received a little bit of additional time to try to get all of this data together, which of course is needed because the department is behind on getting you institutions guidance regarding how to report this data. The department also provided a timeline for additional guidance that it intends to release. Two of these things in April. First, the department has indicated that it's going to be putting out an NSLDS reporting guide for all of this data reporting that's required under the new rule. The last version of this guide that I saw that was put out in 2015, 2016 was almost 400 pages long. So we would anticipate that this is going to be a fairly significant document. Also in April, the department has indicated that it tends to put out new NSLDS reports. So that means it's going to generate reports for institutions that the institutions can access that will have data about their students and completers and programs. In May, the department has indicated that it's going to host a live webinar where it's going to go over the new reports that it has made available so that you can better understand what you're seeing and receiving from the department. And all of this data and these reports it's giving you are supposed to facilitate you, the institution, in pulling together the data that you need so that you can supply that data back to the department by October of this year. And finally, in July, the department intends to host a live webinar during which it indicates it's going to go through that NSLDS reporting guide. Already, and this is critically important, the department has made certain information available about the NSLDS reports that it intends to put out there into the world in the next month or so. The new NSLD reports that will be released in April this month, quote, will support the financial value transparency and GE reporting requirements, but providing schools with a list of students at the detail level, programs at the summary level, where the student's program enrollment status is enrolled, graduated, completed, or withdrawn. So a lot of good information the department is indicating that it's going to supply. Also importantly, the department has already put out, and it did this just last Friday on April 12th, it released the report layouts for these NSLD reports. So the reports themselves aren't out yet, but it has already published sort of the lengthy and detailed report layout. So your information technology and institutional technology folks who may deal with that type of data will no doubt want to see these so they can start preparing so that when the department releases the NSLD reports, they'll be ready to pull them in and analyze them right away. So again, just last Friday on April 12th, the department made these NSLDS report layouts available, and it anticipates making the reports themselves available later this month, along with a webinar in May that will describe how you can read the reports and access the data. Here's some more detailed information. These are the 3 reports that it has indicated are going to be made available and for which the report layouts have already been made available. Again, that's the Financial Value Transparency GE Program Enrollment Detail Report, the Program Enrollment Summary Report, and Students with No Program Enrollment Report. All right. Let's talk about standard and transitional reporting, because one of the big decisions that institutions are going to have to make in the coming weeks as to whether or not they want to participate in the standard or transitional reporting model. This will significantly impact how much data you have to pull together, the cohorts for which you are pulling data together, etc. And even though there was some discussion about this in the rule, there were some questions left to be answered regarding exactly how this was going to be managed by the department. Some of those questions have now been answered in this guidance. So first of all, important, an institution must determine whether it will use standard or transitional period reporting the first time it reports to the department. Okay, so you have to make this decision now. Also, the choice of standard or transitional reporting must be made for the entire institution. In other words, you can't choose to report transitional rates for or transitional information for certain programs and standard information for other programs. So again, you've got to determine which way you're going to break before you start reporting, and whatever decision you make, it's going to apply for every program at your institution. Also, again, if you want to learn more about the distinction between these two types of reporting and what's involved, please go take a look at our desk guide or the 2 webinars we put out in November, because we talk about all of this in detail. Second, on standard and transitional reporting, schools that choose transitional reporting will use that method for the first 6 years the regulations are in effect. This is what we anticipated, but again, it's important to just note you're making the decision now and you're going to be stuck with that decision for the next 6 years. Also, schools that choose standard reporting out of the gates will be stuck with standard reporting for the duration. We anticipate that most institutions, again, for reasons we discussed in our webinar and the desk guide, will want to choose transitional reporting. But the most important point right now is that you've got to make this decision, and once you make it, it applies for every program at your institution, and you will be locked in for the duration. Okay, Some other important information the department provided on this point. Transitional DE calculation. So one of the things you may know if you've been in the weeds on this new regulation and you understand the distinction already between standard and transitional reporting is the idea is if you're engaged in transitional reporting, you're only going to be reporting debt information for students who completed your program in 22-23 and 23-24. So the question, of course, was raised, well, if we're only supplying the debt for students who graduated in those two most recent years, where's the earnings information coming from? Because those students will not already be out in the workforce, and they certainly haven't had, several calendar years between when they graduated and when you would typically sample the cohort's earnings. And the department, and again, we anticipated this. This is how it worked in 2015-16 when the last time gainful employment came around. But it was good to see that the department confirmed what's going to happen is they will take that debt and cost information from the students in the transitional cohort from 22-23 and 23-24, but they will be taking the earnings information from students who graduated during the standard cohorts. Now, you don't have to supply that data, right? The department's going to have that information already, and they're going to go to the earnings agency, which the department also has confirmed is currently the IRS, and they're going to get the earnings information. But the critical idea here is the department has confirmed that if your institution selects transitional reporting, they're going to be using the debt information from one group of students, meaning students who completed in 22-23 and 23-24, and they'll be using earnings information, which is the denominator in those debt to earnings calculations, from students who completed during the standard cohort periods. So your debt information and your earnings information will come from different groups of students, right? Okay, let's also talk about the scope of transitional reporting, which the department gets into in the guidance. So electing to use transitional reporting and rates allows an institution to limit its prior year reporting, which we expected. That's sort of the whole conceit of the transitional reporting. It allows institutions to limit the data reported for private loan debt, tuition fees, books and supplies, institutional grants, and scholarships to cover only 22-23 and 23-24. But what's interesting is when we saw this statement originally, which was included in the April 5th guidance 2 weeks ago, it seemed to imply that institutions electing transitional reporting might not be able to limit prior year reporting for categories outside of these, right? Because as you all know, if you've been paying attention to this rule and you've looked at the data that has to be reported, there's quite a bit that has to be reported outside of the things that are in red on your screen right now. So there was sort of this open question after the April 5th guidance came out. I'm pleased to confirm, at least my view, based on the department's April 12th guidance, what they released last Friday, that this really isn't the case, that it is their intention that if you choose transitional reporting, you will only be reporting for the transitional periods, essentially for all of the data that you're reporting. And this is a chart that came directly out of the department's electronic announcement that was released this past Friday on April 12th. And if you look through the chart, so this is the first year reporting that they're getting into here. You see reporting years is 2024, so that's this year that we're in, right? And what they've done is they've broken out the types of information that must be reported into different categories, right? So and that's understandable because in the regulation, you've got information that's specific to students that are completed or withdrawn. You've got information that's specific to students who are currently enrolled in the most recent award year, and then you've got information that's specific to your program. If you look here, what they're saying is, all right, if you're reporting in the transition or in the standard format, then these are the years for which you'd have to report for each of these categories of data. Or if you're electing the transitional reporting, these are the periods. And if you look, it says for students, right, for completed or withdrawn students, if you go down, you'll see transitional. You see there's a little asterisk there. Okay, this is what we understood. You'll be reporting data for 22-23 and 23-24. But then it also notes for the data that's for students that were enrolled in the most recent award year, right? Again, it's 23-24. It's just that most recent award year. And for the program-specific data, it's 23-24. So it seems to make clear that whether you're dealing with completed or withdrawn students, enrolled students, or program-specific students, if you select transitional reporting, there's no group for which you would be reporting data that goes back before 22-23. Now, I personally would still like to see some really concrete statement from the department making this absolutely clear. But based on this chart, I mean, you can see if you choose transitional reporting, there would not be any basis for you to be reporting any data that goes back before 22-23. So this is encouraging. This is what we thought would be the case. This seems to make sense. But again, it would be great to get some further confirmation from the department. And my hope is in the coming webinars and in the NSLDS reporting guide, etc., they'll continue to clarify and make these points, again, really sound and clear. There was another point that came up in the guidance that I thought was somewhat confusing that is not resolved. It says that the financial value transparency gainful reporting requirements apply to an institution's currently eligible programs and to any of its previously eligible programs for which the department has data in NSLDS. So, if you think about it, the question we're asking here is, okay, we have to report all of this data, and we understand we have to report all of this data for prior award years. But for which programs do we have to report this data? Because, you've got your slate of programs that you're offering today, but there may have been other programs that you were offering 2 or 3 years ago that you don't offer anymore. And it had been our understanding, and I believe it was the case in the prior version of this rule in 1516, that the reporting was limited to programs that are currently eligible. And keep in mind, this entire framework, the Financial Value Transparency and Gainful Employment Framework, the whole idea is that we're establishing eligibility and quality of current programs. So it sort of begs the question why it would be relevant to provide data for programs that you don't offer anymore. They can't lose eligibility. They're not eligible. They're not even offered. Why is it important to gather data and generate numbers for consumer disclosures for programs, again, that aren't even offered anymore? So our expectation was going to be that, when you're talking about prior award year data, you're still saying that you're providing that data for programs that you currently offer. This guidance seems to suggest the possibility that institutions would be obligated to provide data for programs that they may not currently offer if they have a program that was previously offered and there is data still sitting in NSLDS. But then the question would be, how would you even know that? And so, our expectation is some of this may be clarified again with the NSLDS reporting guide that's coming out, etc. But I just wanted to highlight for folks, if you were like us and it was your expectation that all of these reporting obligations would only key off of currently eligible programs, I just want to highlight that does not seem to be the case. The department seems to be suggesting there may be some data reporting obligations for programs that are no longer offered by the institution. So TBD, but I just wanted to flag this for folks. The other thing that popped up in the guidance that was released on March 29th that we thought was very interesting was this one line sort of buried 2 or 3, 2/3 through the guidance. It says the department is taking the position that the termination of a GE program is considered a past performance violation under 34 CFR 668-174. By the way, in the guidance, it actually says 668.74. That's a misprint. The link takes you to the correct place in the regulations. 668.74 is the regulations dealing on misrepresentation. It's 668-174 that deals with past performance. We've corrected that here. But what the department is saying is, if you have a GE program that fails, right, 2 out of 3 consecutive years, and as a consequence is terminated, then that's deemed a past performance violation under this different part of the regulations and results in an institution being treated as not financially responsible. This is a fascinating position the department's taking for a couple of reasons. I mean, one is this regulation talks about fine, limitation, suspension, and termination proceedings and refers to when the department takes an action against an institution to fine, limit, suspend, or terminate its eligibility. So, presumably they're sort of suggesting that if they terminate a single gainful employment program, that would be some sort of limitation or of the institution's participation. It's clearly not a termination of the institution's participation in Title IV. So that's an interesting interpretation. But I think the bigger question is, if you're a large institution, well, let me give you an example. The last time gainful employment came around, there was a program at an elite Ivy League institution with a many billions of dollars endowment. They had a graduate program that it turned out was a gainful employment program and failed. Right? And it got some press because this is a very well-known institution and they, again, have many billions of dollars in their endowment. And so folks the press had a little fun with the fact that their gainful employment program was failing. But But think about this. So what the department is saying is, without regard to the financial wherewithal of the institution or how big it may be, how large its endowment may be, if you have a single gainful employment program that is terminated, the department is saying that's a past performance violation and you will be rendered no longer financially responsible. This is a fascinating position the department is taking. It's also troubling if you're an institution, I think, because there are many, many programs out there that may not pass gainful employment, notwithstanding the fact that the institution overall is very healthy and has many, many other very solid programs, right? So it's an interesting position. I've not heard it articulated before, at least not that I could remember. It really jumped out at me, and I wanted to highlight it for you all. Finally, the department also confirmed its timing for rollout. It notes that in July, it plans to distribute the completers list, very aggressive in terms of timeline, reminds folks that in October the reporting is due to the department, and finally confirms what it has been saying and what we've noted before, that its expectation is to release its first round of calculated rates in early 2025. Just a reminder, there are now 2 challenges to this rule in court. One was filed in December of 2023 by the American Association of Cosmetology Schools. A second was filed by Ogle School of Management and some others in the group in March 2024. Both are down in Texas. And both are currently under consideration. What's notable is the second is seeking a preliminary injunction. So just a reminder for the non-lawyers, it would be possible that the court could continue to consider the case on the merits and even ultimately find against the regulation or find that it violated the Administrative Procedures Act, etc., but not enjoin the rule. And if the litigation took a year or two, all that time the rule could still be implemented and carried out, right? The significance of a preliminary injunction is that the court is saying we're not going to allow the department to even implement the rule while the litigation plays out. That has not been granted yet, but again, the second lawsuit is seeking that preliminary injunction, and we do expect that that will be considered before the rule's effective date of July 1st. So obviously, you don't want to plan on not complying in the hopes that there's a preliminary injunction, but you also want to keep a lookout in case the rule's prohibited from being implemented by the court. Additional roadblocks, the department seems to be trying to allocate the resources to get this rule moving forward. They've clearly committed to that, but we also know that the department is extremely resource constrained right now, so it will be interesting. Even if they manage to get some of these things out and institutions start pushing in all the data, will the department be able to crunch all that data and produce metrics? Obviously, there are real challenges right now the department is experiencing, to say the least, with the FAFSA, with the EAP system, with Easy Audit, several of its critical systems. So we'll see whether or not this system can actually be built and launched effectively. And then the 2024 presidential election will likely impact the ultimate fate of this rule. Finally, just one more reminder, the desk guide that we produced on this rule, the 2 webinars we did, and all our other resources, including the slide deck for this presentation, are all available right there on our higher education, right over there on our higher education resources page. But you can scan that QR code to get to all that, and it's all free. And one last note, this is not legal advice. We are not your attorney, unless we happen to be your attorney. So thank you all. Hope you enjoyed this first higher ed reg effort. And in the future, we look forward to putting more of these out and hope you find them helpful. Until next time, be well.